Hello, this is Professor Weisman's PowerPoint presentation designed to teach the remainder of the criminal justice process course remotely. It can be accessed on Blackboard and on YouTube at Professor Weisman's CJ Courses channel. This is Unit 2, and the presentation will discuss Miranda warnings. In Unit 2, we will be looking at the case of Miranda versus Arizona, Miranda warning requirements, and problems associated with the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. These words are, of course, the Miranda warning. In order to understand the Miranda warning, let's look at the actual Supreme Court case itself. A link to the opinion is found on the slide. Miranda versus Arizona addressed a common issue in 4 different cases involving interrogations of suspects while they were in police custody. In each of the cases, the defendant was questioned by law enforcement officials in a room in which he was cut off from the outside world, and he was not given a warning of his rights at the start of the interrogation. The questioning resulted in confessions which were admitted at each defendant's trial. We will look at the cases in the next 4 slides. In Miranda versus Arizona, defendant Miranda was arrested for kidnapping and rape and taken to a police station where he was identified by the victim. He was then interrogated by 2 police officers for 2 hours, which resulted in a signed, written confession. At trial, the confession was presented to the jury. Miranda was found guilty and sentenced to 20 to 30 years imprisonment. In VIGNERA v. New York, defendant was apprehended by New York police in connection with the robbery of a dress shop. He was taken to the station and admitted the robbery and was placed under formal arrest. He was then questioned more by an assistant district attorney in the presence of a court reporter who transcribed the questions and answers. At trial, the oral confession and the transcript were presented to the jury. VIGNERA was found guilty and sentenced to 30 to 60 years imprisonment. In Westover versus United States, Westover was arrested by local police in Kansas City as a suspect in 2 robberies and taken to a local police station. A report was also received from the FBI that Westover was wanted on a felony charge in California. Westover was interrogated the night of the arrest and the next morning by local police. Then, FBI agents continued the interrogation at the station. After about 2.5 hours of interrogation by the FBI, Westover signed separate confessions which had been prepared by one of the agents during the interrogation to the felony charge in California. These statements were introduced at trial. Westover was convicted and sentenced to 15 years imprisonment. In California v. Stewart, during the course of investigating a series of purse snatch robberies in which one of the victims died of injuries, Stewart was subsequently identified as the signer of checks stolen in one of those robberies. He was arrested. At the station, and over the next 5 days, he was interrogated on 9 different occasions. During the 9th interrogation, Stewart stated that he indeed had robbed the deceased person, but had not meant to hurt her. At trial, Stewart's statements were introduced. He was convicted of robbery and first-degree murder and sentenced to death. The issue common to all 4 cases was whether statements obtained from an individual who is subjected to custodial police interrogation are admissible against that person at a subsequent criminal trial. The Supreme Court held that there can be no doubt that the Fifth Amendment privilege is available outside of criminal court proceedings and serves to protect persons in all settings in which their freedom of action is curtailed in any significant way from being compelled to incriminate themselves. The Supreme Court further noted, as such, the prosecution may not use statements stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. The court noted that by custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of activity in any significant way. The Supreme Court further stated that a defendant must be warned prior to any questioning that he has the right to remain silent, that anything he says can be used against him in a court of law, that he has a right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning, if he so desires. In an interesting side note, after Miranda's conviction was overturned by the Supreme Court, the state of Arizona retried him. At the second trial, Miranda's confession was not introduced in evidence. However, he was convicted again and sentenced to 20 to 30 years in prison. Although, as the Supreme Court noted, Miranda warnings have become embedded in routine police practice to the point where the warnings have become part of our national culture, police are only required to warn an individual whom they intend to subject to interrogation while that person is in custody. Arrests can and do occur without questioning and without the Miranda warning. One need not be Mirandized to be arrested. Indeed, if a suspect talks before interrogation commences, there is no Miranda required. As mentioned, the Miranda rule applies to the use of testimonial evidence in criminal proceedings that is the product of custodial police interrogation. Therefore, for Miranda to apply, 6 factors must be present. 1. The evidence must have been gathered by police. 2. The evidence must be testimonial in nature, not, for example, fingerprints. 3. The evidence must have been obtained while the suspect was in custody. 4. The evidence must have been the product of interrogation. 5. The interrogation must have been conducted by police or other governmental agents. And 6. The evidence must be offered by the prosecution during a criminal case. So then, what does custody mean in connection with Miranda warnings? Custody means that a suspect is deprived of his or her freedom of action in any significant way, that he or she believes they are not simply free to go home or to leave. To determine whether a suspect is in custody, we look at several factors. Whether the suspect is questioned in familiar or neutral surroundings rather than, say, at a police station. The number of police officers present. The idea here is that the more officers present, the less free the person feels that he or she can leave. Any degree of physical restraint. The duration and character of the interrogation. Is it very brief or is it long? Whether probable cause exists to arrest the suspect. Whether the suspect is even a target of an investigation. The language used by officers to call or to summon the individual. And lastly, the extent to which suspect is confronted with evidence of guilt. There are 3 major problems or issues associated with the Miranda warning: circumvention by law enforcement officers, different warnings used, as well as language and education barriers in the warnings. Some police departments give specialized training to interrogators with regard to the Miranda warning to teach them how to influence a suspect's decision to actually waive the right. For example, an officer is allowed, before asking the suspect a single question, to speak at length about the strength of the case and the amount of evidence collected. The officer then will keep quiet, hoping that the suspect talks in an attempt to refute the evidence presented. Another tactic is that the officer simply does not ask any questions. He or she merely sits in the interrogation room waiting for the suspect to begin to talk. Another problem is that there is no standard warning. each law enforcement agency is free to create its own form so long as the basic ideas expressed by the Supreme Court are met. The links below are typical. A study looked at Miranda warnings from 560 different law enforcement jurisdictions across the country. The researchers found that Miranda warnings used words and had concepts that varied from very simple comprehension, less than a third grade reading level, to requiring sometimes a college education. For example, the word right, R-I-G-H-T, only requires a fourth grade reading level when referring to direction, for example, turn left or turn right. However, when the same word concerns a legal claim, that is a legal right, it requires at least an 8th grade reading level to more fully understand it. Moreover, there are many issues that pertain to the Spanish translation of Miranda warnings, ranging from small translation errors to substantial errors such as the omission of essential rights that the warning protects.